Good afternoon, everyone. My name is Jeremy Schwartz. I'm one of the partners here at Stringer Management Lawyers. To my left or right, depending on how your screen is set up, is my partner Landon Young, and Ryan Conlon will be joining us shortly for his presentation. Thank you for joining us for this unusual scenario of another quarterly webinar where we're talking about last year and frankly, I don't think there's been a year in recent memory where the events of last year will have such a profound impact on the year to come. So we have an awful lot to go through. We are going to have a Q&A at the end. If you're familiar with the program and the platform, on the right-hand side in the control panel, you have the ability to enter questions. And if you submit those, we'll curate them and get to as many as we can at the end. But without further ado, Landon is going to take the first mic and help you guys through, frankly, what just came down yesterday, a very interesting decision or non-decision from the Supreme Court of Canada that I think will have significant ramifications in the many years to come. Landon?
Thank you, Jeremy. So I'm going to be talking about this case that Jeremy is referring to, and then more broadly, the implications for employers, and also how to make sure your termination clauses will hold up in court if they are litigated. And to answer the question in the title, the answer is yes, they still do work, but making them work is trickier than it used to be. And but you can still get there. It's just the courts are making the path a little bit narrower for termination clauses to get through. So, Jeremy, I need control over the deck. Okay. Okay. All right. So we'll jump right into it. The case is Waxdale and Swegon, North America. It's a case that I've been arguing on behalf of a client. And this case, many of you may already be familiar from it. It's received a lot of attention in the employment and HR law world because of its serious impact on termination clauses. And for those of you who attended our annual conference in the fall, you may recall that I spoke about the case there. So some of what I'm about to say may be repetitive. So please bear with me, but for the benefit of those who may not be as familiar with the case, I need to get into some background on it. And as well, it might be a good refresher for those of you who actually did hear about it as well. So to cut to the chase, in this case, at first instance, the motion judge upheld the termination clause. Then the plaintiff employee appealed to the Ontario Court of Appeal, and the Ontario Court of Appeal found that it was void and reversed the decision of the first judge. And then on behalf of our client, I applied for leave to appeal to the Supreme Court of Canada, and unfortunately the Supreme Court has denied leave yesterday. So the upshot of that is this case is solidified as the law in Ontario, unfortunately for employers. Now, the Supreme Court does not give reasons for denying leave, and most cases do not get leave, so it's impossible to know why they didn't give leave. I'll just say if they didn't give leave in this case, it's hard to imagine what employment cases would meet their bar for having a significant enough issue to receive leave. But that's the test, essentially, that the case has to raise an issue that the court considers to be of public and national importance to receive leave. Okay, so what happened in the Waxdale decision from the Ontario Court of Appeal? Well, what the Court of Appeal said is that where you've got a contract that has a clause that says the employee receives no notice in the event of just cause, then that will cause the not for cause clause, sorry for the rhyming, to be held unenforceable, even if that without just cause clause is otherwise enforceable, and even if they are in separate clauses that are standalone clauses. Now, many of you are probably saying, well, what do you mean? Isn't that just the usual law that if you have just cause to terminate an employee, you don't owe them notice? Well, that's the rule under the common law. But that's not the rule under the Employment Standards Act. And the distinction is the common law is effectively judge-made law, whereas the Employment Standards Act is law that is set down by the government, in this case, the Ontario government, and set out in the legislation. And the standard is slightly different under the Ontario Employment Standards Act, unlike most other provinces, by the way, that just say an employee receives no notice in the event of just cause. But in Ontario, it says the employee is disentitled from notice if they are guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. And the courts have also said that is actually a slightly different and higher standard than just cause, because under the common law, an employee might be guilty of just cause, but it may not be willful. So for example, for persistent poor performance. Although 99% of the cases that do find just cause, there is a willful component to it. But in any event, on that very technical basis, the courts have found this slight shading of difference between the common law standard and the Employment Standards Act standard. And applying the general rule that was set down by the Supreme Court about 30 years ago in a case called McIntyre and Hodge, that case said that if a termination clause violates the ESA, then the termination clause is not enforceable. So what the court has done is basically applied that principle, but in a new way, so that even where a just cause clause is there, but it can be considered to violate the ESA, even if you have the valid clause, it will effectively kill the valid clause. Jeremy, next slide. Oh, thanks. So what are the implications of this for employers? The implication is that if your clause in an employment contract has some language that says the employee may be terminated without notice for just cause, then even the, let's say, good part of your contract, being the without cause section, that will not be enforceable. And the net result is that the great majority of employment contracts out there are actually now effectively unenforceable. And that means that the employees will have a potential claim for reasonable notice under the common law. And as most of you know about the common law, that can be quite generous. Some people think there's a month per year rule of thumb, but there isn't. It can often be quite a bit more than that, depending on various factors that apply. And the courts have broad discretion to determine what common law notice is. And so that, you know, the reason that these termination clauses have become quite common in recent years is that employers were frustrated at how generous the courts had become with awarding common law notice, and so started using these clauses. Unfortunately, what happened is that everybody assumed that the just cause without notice clause would be fine because that reflects the common law, but didn't think about this technical issue that the courts might seize upon, being that distinction between the ESA and the common law. So if you have one of these contracts, what do you do about it? Well, it's not the end of the world. You can enter into new contracts with your employees with repaired language that removes the offending just cause clause. The trick to it is that the employee should be receiving some form of fresh consideration for signing the contract, otherwise it may be considered unenforceable. Now, what that consideration might consist of, it could be a relatively modest payment. It should be something more than just $1 or $2, but let's say if it was $50, for most people that should be enough. It could be linked to a promotion, a raise, or something else of material value to the employee for signing the contract. And when presenting it to them, I recommend being completely upfront as to the reason. You could simply say that there's been a recent legal development that requires employees to make clear that in the event of just cause, they will receive their ESA entitlements, or they can't have such language. So, here we are, we're amending our contracts to make sure that no one receives less than their ESA entitlement on termination, and here it is. And, as part of that, I would also bring the clause to their attention so that they can't later on claim they had no idea what it was that they were agreeing to. And then in terms of how to get it right going forward in light of this Waxdale case, which has now been solidified as the law of Ontario, if you're drafting the clause yourself, do not refer to just cause. If you're providing for ESA-only entitlements, do not refer to just cause. So do not have a section that says, in the event of just cause, you receive no notice. If your clause does provide something more than ESA minimums, then you could draft it so that the just cause section applies only to those extra ESA entitlements. But that could be tricky drafting, and I would certainly recommend you get legal advice on how to do that. And also just generally be very careful with complicated formulas in your termination clauses or clauses that have a whole bunch of different elements to it. There have been many, many cases in Ontario where employers have tripped over their own language by having, for example, a clause that says, they'll receive 2 weeks per year of notice for every year of service. And the employer thinks, oh, well, that's better than the ESA, so I'm fine. But it may not provide for severance pay, which under the ESA cannot be avoided by a working notice. So the best way to draft these things is to keep them simple. You make clear that the employee will receive such entitlements as they have under the ESA, but they're not entitled to any further notice. So that's it for my section. So over to Ryan. Thank you.
Hello, and thank you everyone for joining us this afternoon. Landon gives us a lot to think about, and maybe that the direction, the way that our courts and tribunals are heading on employment matters is certainly not getting more pro-employer, shall we say. All right, I have a couple things I'm going to cover. First of all, that's the occupational health and safety related issues as it relates to COVID-19. There's been 2 cases that have arisen, I think, that are kind of interesting, that talk about some factors that are common to all employers. One comes out of the always litigious and aggressive teachers unions, and then the next comes out to perhaps the most sort of the front lines of the COVID-19 battle, which is the in long-term care homes, and may give us a preview of some of the litigation to come around vaccine testing. So the first thing I wanted to cover, Jeremy, if I could just get the control here. The first thing I wanted to cover is is a case that comes out of the long-term care sector, and this is the case of Crescent Care nursing homes versus the Christian Labor Association, CLAC. Those of you who attended Jeremy and I's presentation on vaccine testing, this is building on some of the themes we talked about. This was a grievance that relates to just a situation where the employer had imposed a policy unilaterally making sure that all staff are tested by means of a nose swab every 2 weeks for COVID-19. I mean, obviously, this is the most highest risk sector, as we'll see when we get to the WSIB statistics. But the union argued in a similar manner that the unions, way back when they were challenging mandatory influenza vaccinations, that the policy was both unnecessary and unreasonable. As unions have, as there's of course, those of you in unionized workplaces have heard the term KDP test before. There's a general obligation on management to exercise their discretion reasonably with respect to the rules of the workplace. And not surprisingly, management litigated this matter with the union. If you get the next slide. The union relied on older cases again. Those are the cases that, as I said, involved around influenza, and even some decisions where unions had what I thought was a surprising level of success in dealing with alcohol-related cases and stuff along those lines, where even in safety-sensitive situations, random alcohol testing became a bit of a difficult issue for employers. But ultimately, the arbitrator came down on the side of the employer and just basically said, look, we're dealing with a global pandemic. Albeit there's no question that having to stick something up your nose is obviously an invasion of privacy. But when you're balancing the interests of the life and death consequences of the clear life and death consequences of exposing patients and others in a long-term care home to COVID-19, it's essentially a death sentence versus the inconvenience of a test. Unlike in other cases where the flu vaccines, where there had been some real question about whether of the merits of the vaccines and even other measures taken to remediate the issue by the employer. Here, it was a fairly easy decision for the arbitrator, and ultimately found that the test is reasonable and you've got to cooperate. So what does that mean? What I think it means is we're heading into a world where perhaps if there is going to be objections to the COVID-19 vaccine, and obviously we're still in a place where we're not even close to being in a place for everyone who wants it getting it, but we're probably going to get to a point where there are some that are going to say, I don't want a COVID-19 vaccine. It's an invasion of my personal privacy, or in some cases, perhaps an invasion of their religious rights, or and even some smaller subset of cases dealing with disability-related issues. But I think for leaving these sort of religious and disability exceptions aside, just for the generic, I think this is an invasion of my privacy. This case is at least a suggestion that there's not going to be a lot of patience from that. From labor arbitrators and from labor boards dealing with work refusals and issues along those lines. So for those of us that are on the side of things that if you have no medical reason not to get a vaccine and you're not doing it, that is of course you're right. That the government has made clear they're not going to make vaccines mandatory. But you're right. But as a de facto situation, if you want to actually leave your house and go to work or go to a theater or go to a sporting event or even get in a taxi for that matter, it seems to me that there's not going to be a great deal of legal options, that basically the broader public safety is going to trump some sort of general sense of privacy or even safety concerns about an early stage of a vaccine. The next case I want to talk about, let's get to the next slide, that comes out of the context of the teachers unions that I alluded to. These were cases where basically what was interesting about it is this is what you might want to call the grab bag appeal. That basically the way the Occupational Health and Safety Act is set up is if an inspector issues an order, or if a union or worker calls an inspector and says issue an order and the inspector says I'm not doing it, that union or worker has a right to appeal the refusal of the inspector to issue an order in the same way that an employer can appeal an order that a Ministry of Labor inspector has made. So, but ordinarily, of course, those are specific orders dealing with a specific issue at a specific workplace. What the union did is, rather than appeal about one specific work issue at one specific school or even a school board for that matter, basically a group of teachers unions, because the teachers unions are divided between sort of public and publicly funded Catholic schools, elementary school, high school, French school, that sort of thing. So there's a variety of different unions involved in terms of the bargaining rights for teachers. And all of them essentially came together, publicly funded anyway, and said that, that basically omnibus, we want to appeal that on a long list of things, that the conditions at the schools were not safe for returning to work. Next slide. So that obviously that presents some challenges, and the government and the school boards basically said, look, you can't bring a class action, if you want to call it that, kind of omnibus or whatever word you want to use, list a case all at once about every single dispute at every single school at every single school board in Ontario. If you want to bring an appeal, you're more than welcome to, but you've got to deal with one issue at one work site. Which, I mean, the union certainly pointed out that would make it cumbersome. We'd have to have 10,000 appeals, and there's obviously perhaps some merit to that position in the sense that, practically speaking, it would just be such an unwieldy litigation. But the labor board, in a fairly lengthy decision by board chair, Bernard Fishbane, basically came to the conclusion that, well, the statute's written the way it's written. I'm not going to comment on the merits of these objections, but just as a matter of law, you can't bring a case like this if you wanted to. If you want to bring a case like this, you're going to have to get the government to amend the Health and Safety Act to reflect the ability to appeal sort of a broad cross-section of issues and a broad cross-section of sites. Next slide. So what does that basically mean? For those of you that are multi-site employers, I think, or government employers that have, multiple sites, multiple locations, this means that sector-wide appeals are not going to be happening, which, from an employer's perspective, is considerably easier. And it's also completely consistent with what the statute is about, right? The statute was written in a way that basically, if you don't like the single decision of a labor inspector about a single issue, you can bring that to the labor board. I mean, really, to try and sit there and suggest that a single inspector or a group of inspectors commented on every single site, it's just not what was contemplated by the statute. It wasn't meant to be a broad policy grievance with respect to safety issues. It was set up in such a way, as it's currently framed, to dispute the decision of an inspector about a single workplace, a single issue, a single section of the act, remembering that an order or refusal to issue one has to be based upon the legislation. Of course, this doesn't foreclose an appeal by individual schools at individual issues, but certainly it was a legal victory, albeit not a surprising one for the government. WSIB. Wanted to talk a little bit about workers' comp this year. WSIB has some good news. I mean, when they deserve some praise, I'll give it to them. They've frozen premium rates for 2021. That means you'll be paying the same rate as 2020, remembering now that we're sort of out of the surcharge world, that basically the way things work now at WSIB in terms of how your rates are set are the same as like your car insurance. It goes up, it goes down. It's a premium rate. It's not like a surcharge or refund system that they had historically. So this is welcome relief for employers that have been hit hard by the pandemic. And it's a legitimate savings. It's not a deferral of costs. Where governments throughout the pandemic had been delaying the filing of income taxes or paying certain taxes and things. It's direct actual relief from some cost increases. So that's good news for employers, but remembering that once we get back into next year, that any claimed costs associated with the previous years will be taken into account in terms of how your rates are going to be dealt with. And I think as we get towards the end of this year, I'm hoping to do a webinar to going through how rates are going to be increased. I think there's a lot of misunderstandings about that. And I will do so towards the end of this calendar year. Next is the objection process. People have been asking me how appeals have been proceeding. I'm actually happy to report that although certainly there's been a number of delays in adjudication, we're actually now getting much better access to file documents in terms of making those documents available electronically. That's a more efficient way and more modern way of doing things. The WSIB has, up until very recently, been still is the master of snail mail and fax communication, still a very 1980s, early 1990s way of communicating. So that I'm hoping that this is one of the many things that in terms of the legal world that's been pushed into the 21st century by necessity, as it turns out. WSIAD appeals, much like many other forums, tribunals, the labor board, human rights, and to some extent the courts, these hearings are now proceeding electronically. Those of you who have been involved in litigation with WSIAD or otherwise will say that most people it's different and maybe it has its shortcomings, but it still has certainly some advantages as well. And anyway, it's proceeding electronically and will be doing so for the foreseeable future until the pandemic's resolved. And again, it's hard to say whether or not, to some extent, some of these electronic hearings may become more of a common thing. That remains to be seen. In the next slide, we'll take a look at some claim statistics for WSIB. These are the most current statistics I have available. There's been approximately 10,000 claims filed claiming that a worker's got COVID, and if it can be established that a worker got COVID in and of the course of employment, it's a workers' comp claim like any other. We can see of the claims allowed, there's been approximately a total of just over whatever it is, 13,000 claims filed. More than 10,000 of those were approved, just under 2,000 of those were disapproved, another 800 or so pending. Next slide will tell you where the exposure is coming from, and I don't think this is going to. These are by rate class. The board is organizing this, but as you can see, we're looking at the vast majority of these claims coming out of the long-term care sector, by 4,500 of those. Agricultural claims are 1,500. A lot of those are migrant workers. That's been well documented in outbreaks in that area. And then again, hospitals. After that, it's Schedule 2 employers, which a lot of those are going to be healthcare as well. Schedule 2 is mostly government. entities, including long-term care homes that are operated by municipal governments. That's what a lot of those claims are. And then it goes after that into sort of like, again, so it's all, if you take a look at the number, I mean, of healthcare claims, it's close to 80–90% of these are in the healthcare sector of one kind or another. So we can certainly see that it has hit the healthcare sector worse than any other sector. So those are my comments. We're going to turn it back over to Jeremy, who's going to talk to you about the next big risk coming up in employment law.
Thanks, Ryan. I'm going to talk about a topic that has been coming up in just about all of our sort of practical sessions, whether it be dealing with layoffs or leaves of absence or attendance management throughout this pandemic. And I have to say, as some of you have been watching this or been changing your plans on the fly with each new announcement about leaves of absence and layoffs and things that have been going on, not just in Ontario, but in other provinces, with many of those changes being announced on the eve of the expiry of certain items. This to me is sort of a sleeping giant that we just keep pushing this issue down the road. We have this ongoing pandemic. We have employers who found a way to survive the first round of lockdowns, tried to find a way to start recovering. Then we have the second and maybe arguably another third wave, which is worse. Reports are saying that this may continue or get worse until it gets better once we have greater herd immunity as vaccination rates rise. So ultimately, it's probably going to get worse before it gets better for a lot of companies. And I think what a lot of employers need to realize is as they make these decisions, when they make them is almost as important as what decision they make. I'm going to take you through some of that now. So first off, let's start with the law as it stands at its foundation. Unless you have an agreement, whether that's in the contract already or you have an implicit agreement by past practice in respect of that employee or the employees in that classification, non-union employees we're discussing right now, then a layoff is a constructive dismissal, or it can be. If the employee says, you can't lay me off, that's a constructive dismissal, then they can quit and sue you, alleging constructive dismissal. They also have an option of telling you, look, you don't have the right to implement a temporary layoff. That's a constructive dismissal, but I will consider a recall as a way of mitigating my losses. And they don't have to say it in formal legal jargon the way I just did. They can say it in some sort of matter-of-fact way. Well, I'm not okay with this, but I need a job, so you call me back. I'm still not okay with what happened, and we'll talk about that later, right? In some cases, employees may be required to return to work when you recall them, even if they're taking the position that what you did was a violation of their contract because you didn't have the express or implied right to lay people off. Now, very importantly, some employers will have the impression that if you're an hourly employee, you've implicitly agreed. If you're in certain industries or sectors, you've implicitly agreed. If you're working in a warehouse, you've implicitly agreed. That's not necessarily the case. And over, the courts have demonstrated that they are unwilling to give employers, if you heard anything out of Landon's talk this morning, more and more the courts are policing these implied management rights in non-union agreements and saying, you don't have the implied right to do something, even though the Employment Standards Act has rules about what is a temporary layoff and when it becomes a permanent layoff. The courts have consistently found that that does not say anything about giving the employer the right to impose unilaterally a temporary layoff in the first place. So just because the ESA says when it reaches 13 weeks in 20 or 35 in 52 weeks, depending on the circumstances, does not mean you have the right to lay them off in the first place. It just means that if you have that right, then, or if you implement that layoff, then that's when the temporary layoff will become permanent. Now, other ways in which you can effect changes during the pandemic, and employers have been doing this in many cases without any agreement and with very little communication, If employees' hours and comp has been reduced by 10% or more, that would ordinarily be a constructive dismissal. Sometimes less could be, but 10% has been a general rule that if it's about that, it's pretty likely that any employee can quit, sue for constructive dismissal. Again, they may or may not be required to continue working under the altered terms and conditions, but the more you reduce their hours, the more you reduce their compensation, the less likely a court is going to say that they had to take that recall or they had to work under those modified conditions. Now, if the employee continues without expressly objecting to the new hours or the new pay for a reasonable period, they may be deemed to have condoned the change. I will caution you that if they do so because you communicate that these changes are temporary to respond to COVID, it's unlikely that they can't at some point say, even 6, 9, 12 months down the road, look, you said it was temporary. This is clearly not temporary anymore. This is indefinite. I think I've been constructively dismissed. So keep an eye on that. And just because they're condoning it for now, because they need a job and they're terrified that if they walk, they won't find something during the job market we have right now, that does not mean they're accepting their fate. And it doesn't mean the courts will hold them to that. Now, employees who agree to a layoff implicitly in their conduct or condoning it, or who agreed in their contract, they are not constructively dismissed. That's the difference between a constructive dismissal and just changing a contract. Is it's a bilateral agreement. You and the employee agree. If you agree and it's an enforceable agreement and you've given them something in consideration for that agreement, then it's not unilaterally a change imposed by the employer. You're free to implement that layoff in accordance with your agreement and, of course, the Employment Standards Act. Now, early in the pandemic, just about 13 weeks minus 2 days before everyone who had been laid off in March was going to have a deemed termination by statute of their employment contract, the Ministry of Labor and the government legislated a new regulation, and they promulgate this regulation, which creates the Infectious Disease Emergency Leave under the Employment Standards Act, and essentially deems anyone who was laid off from March due to COVID not to be laid off at all. The clock never started running on when the layoff became permanent, and instead they're deemed to be on a statutorily protected, job-protected leave of absence. Unlike other leaves of absence, there's no obligation to continue benefits under the IDEL, though if you have contractually agreed during leaves of absence to provide benefits or certain benefits, you may be required to do so. And you need to understand, though, that this, like the prescription on when a temporary layoff becomes permanent under the ESA, does not give the employer the right under the common law to impose a layoff. It's not a right granted by statute. So too, the deeming of a layoff into an IDEL leave, into this IDEL form, doesn't automatically prevent a constructive dismissal under the common law. Now, we have not seen any litigation on this yet. I've been looking every single week, frankly, and right before this presentation. I think that this is one of those issues that may be one side of the sleeping giant here. So the left side of the sleeping giant is employees who have been condoning these temporary layoffs, which were converted into IDEL, may be waiting to see how things go, how they're treated during these layoffs or leaves of absence, what happens when it's time to return them from those leaves of absence, and how the employer determines who to bring back and who not to recall at various times. So I think that this is a legal issue that is just waiting. It's sort of a landmine buried under the ground, waiting for someone to step on it. Currently, the IDEL, this deeming language, expires on July the 3rd. For those of you who have been watching our presentations and reading our updates, or just keeping an eye on things generally, you'll know that the government has already 3 or 4 times extended when that deadline was going to be. Most recently, it was going to be January the 3rd was the expiry, and right at the end of December, they extended it so that it would expire on July the 3rd. Who knows if we get to July the 1st and they do it again. In the meantime, we should assume that anyone who was on a layoff, who was given a notice of layoff due to COVID from March of 2020, may be deemed to be, at least for employment standards purposes, on IDEL until July 3rd of 2021. Now, the government, again, has extended this multiple times, so we have to keep an eye on it, but that, for employment standards purposes, appears to be where we are. Now, this is the other half of the sleeping giant to do with these layoffs and leaves, which is the right to reinstatement. And the right to reinstatement is something that ordinarily is very easy for an employer to comply with, and maybe a hardship to bring someone back after you've had 12 or 18 months where they've been off on a leave, but ultimately it's one that's fairly straightforward. Someone is off on a statutory protected leave. That protected aspect means they have the right to their job, and even if you've divided their job up among 5 people while they were on that leave, or you hired someone temporarily to cover a mat leave, or whatever it is, this is still their job. And you have to take back those pieces that you've divided up and reconstitute their job if you can, when they are ready to return, or you have to get rid of the person who's been brought in temporarily to do their job. And outside of pandemic times, where you're dealing with a handful of employees out of a larger whole, that's a much easier thing to do. Unfortunately, I think that's going to be much more difficult where you have 30, 40, 100% of your workforce at various times going off on these IDEL layoffs or what have you. How do you bring people back while you're still trying to manage the reorganization of your workplace? You're still trying to survive and recover from this year and more of pandemic by the time this is done. And how do you conduct that assessment on a group basis as opposed to this individual right under the ESA case by case? And so I think we're gonna have to wait and see how that goes. How do we avoid these claims? I'm going to give you some practical tips here. First, keep employees updated. People who are in the dark, who are terrified about what's going to happen with the company and with their jobs, are more likely to start litigation or to cause problems. Send out regular communications, especially to people who have been off for months. You want to lay off on the IDEL and not terminate folks until the expiry. So unless you have a crystal ball, and I've been saying this since the IDEL deeming provisions came in, there really isn't a good reason to terminate someone's employment, other than the continuation of their service for this additional few months, which might give them at the end of this another week or two of pay in lieu of notice under the ESA. What we're really talking about here is someone who has the right to their job back when the leave is deemed to be over. So if you terminate them in March and in July someone else is doing a job that's very similar, well, guess what? They might have a claim that you violated their right to reinstatement. You're going to have litigation and you may have to settle, or you may have to go to the labor board and deal with this. So let's avoid that. Let's kick this can down the road as far as the government has asked us to do so. Ask for severance volunteers. You let everybody know that you need to continue these layoffs, and then you say, if there are folks, you can target specific folks and say to them, look, at this time, we don't believe we're going to have a job for you when the leave is over in July, but we're prepared to leave you out on that leave if that's your preference. If you'd like a package, let us know and we'll work with you. Or just offer them a package and then tell them if they don't sign it back, they're just going to be placed on that leave. And be sure that it's very clear that this package is voluntary and that they will get all their entitlements under their contract and the ESA. And of course, if you want to release, you have to give them a bit more, right? You want a secure agreement for partial and modified returns. These don't necessarily have to be with consideration. If they're with consideration, they're more likely to be enforceable, but you want there to be buy-in, right? So even from just a human perspective, getting people to agree to come back on modified terms is a much easier way to avoid issues later, and it shows good faith. And of course, records and reasons. Be able to show, if you get challenged down the road, what was the basis for recalling one person and not the other, okay? You want to keep records and you want to have valid lawful considerations that are recorded. And finally, if you respond to these claims, and many of these may not come for some time, but you may have demand letters in the event that you're communicating with employees about certain things that you're doing, you want to consider offering people their job back. If you've laid them off or terminated their employment, but they weren't actually recalled to work, well, reinstating their employment to inactive status, really not much skin off your nose, might be something to consider, and they may have to accept it as a way to mitigate. Consider implementing things on a temporary basis. We can consider certain legal arguments about the deeming provisions of IDEL, but again, we haven't seen enough case law or any case law on that to know how that will play out. And the issue of whether there was a frustration of employment for employers that were hardest hit and really had no choice. And finally, feet to the fire on mitigation. Every demand letter I've been getting these days, the employee's lawyer has been saying, you can't really expect my client to mitigate during a pandemic. And the answer is yes, we do. So do the courts. And if possible, send them to a job search site or pay a little bit of money to help them with some job searching and give them copies of all the applications they should be making. And of course, hopefully they find a job. And if they don't or don't bother to apply, well, now you have an argument that they failed to mitigate their alleged losses. So those are my comments on that. And if anyone needs more assistance with that specifically, of course, I'd be happy to help directly. And now I'll hand the conch over to Landon, who will take us.
Thank you, Jeremy. I'm back. Unfortunately, I have more bad news from our Supreme Court. Well, bad news from the employer perspective, I suppose. If you're an employee, it might be good news. So it's all on the issue of the duty of good faith in the performance of contracts, or another way to express it is the duty not to act dishonestly or in bad faith in the performance of a contract. Just a little bit of background on this issue. There's been some legal debate over the last couple of decades as to whether or not employers have a general duty to act in good faith or not to act in bad faith or dishonestly in the manner they employ, or rather the manner they perform employment contracts generally. It's been quite clear from the Supreme Court since I believe it was in the late 90s, the case of United Wallace and United Grain Growers. That case changed the law and said that an employer on termination has a duty to act in good faith and not to act dishonestly in the manner it carries out the termination. And since then, the courts have, for the balance of authority has been that duty of good faith has been limited to just the way the termination is carried out. And that's what the Ontario Court of Appeals said in a case a few years back called Grismondi and City of Toronto. And there the court said, no, that duty only applies to how the termination is carried out. It doesn't apply to things the employer might have done in the past or that had nothing to do with the termination. So this new case from the Supreme Court, though, will be giving extra weight to the plaintiff side lawyers who act for employees, who are going to be pushing the argument that now the duty actually applies generally to the performance of an employment contract by employers. Okay, Jeremy, next slide. There we go. So this case is CM Callow Inc. in Zollinger. And I'll just first give you a summary of the facts, because in our legal system, when cases are litigated, everything gets driven by the facts. And when you have facts that are bad, then you often get law that can not be very helpful for employers as well. So this case was actually not an employment contract case, but a commercial contract case. But it can still, the principles set out in this case, by the way, can still apply to employment contracts, because all employment relationships under our law are considered to be contractual in nature. They're essentially employment contracts. Even if you don't have a written employment contract with your employees, the law deems that you have a contract of employment. So principles that the court set out in non-employment contract cases can apply to employment contract cases. All right. So that having been said, what were the facts in this case? Well, you had two parties to a contract. It was a 2-year contract where a service provider provided snow removal services to a condo corporation. And the condo corporation residents were actually quite unhappy with the snow removal services that they were receiving. And they had a meeting with the provider where they discussed it, and it seemed that the error was cleared and everyone was happy, and it looked like things were going to continue on. Despite that, though, the condo corporation decided, I think it was like in the winter, that they were going to terminate the contract, but the contract wasn't up for expiry until September. So despite having already made up their mind to terminate the contract, they didn't tell the service provider that immediately. And in fact, 2 board members spoke to the provider and suggested that the contract would be renewed, and certainly didn't say anything to the service provider to make him think that the contract would not be renewed. And the contract, by the way, provided that it could be terminated on 10 days notice. So the condo corporation thought, well, as long as we just provide the 10 days notice, then we're good, and whatever. Following these conversations the board members had with the service provider, he actually provided some freebie summer work, some gardening for the condo corporation. And he also had an opportunity to bid on some other snow removal contracts, but didn't, thinking that his contract with the condo corp would be renewed and was secured. Despite that, though, the condo corporation carried through on its decision to terminate the contract, and they provided the 10 days notice as required by the contract. So the condo corporation performed the contract to the letter, did everything they were supposed to under the contract, but obviously didn't treat the service provider very well in the circumstances. And obviously he felt aggrieved. So what did the court do about it? Well, the court said that even though we'll start with the initial trial level because there were several levels on this decision. The initial trial level court said that even though the condo corp had abided by the contract, it acted in bad faith, and as a result, the service provider was entitled to damages that were suffered as a result of the non-renewal of the contract. That decision was appealed to the Ontario Court of Appeal, which disagreed with the trial judge and said that, in fact, there was no cause of action here, that even though the service provider might have relied on what it thought was going to be a renewal, in fact, the condo corp performed the contract in accordance with its terms, and so he wasn't entitled to damages. Then this went to the Supreme Court of Canada, obviously the highest court in our country, and the appeal was allowed, and the initial decision of the trial judge was restored. And again, just like the trial judge, the Supreme Court said that the parties to a contract must perform their contract honestly and in good faith. And even if they perform the contract to its terms, but do so in a bad faith or dishonest manner, they can be held liable for damages, the same as if they had breached the contract. So this case could have some far-reaching consequences for employers. And we've already had the duty of good faith when it comes to termination, and through a lot of case law, we have a pretty good idea of what that means. It means things like an employer can't assert or should not assert just cause for dismissal when there are clearly no grounds to do so. An employer can't lie to an employee as to the reason for the termination, and an employer can't hold back an employee's minimum entitlements under the Employment Standards Act as a way to pressure the employee to sign a release, things like that. So that part is quite clear. But what would this duty mean if it applies generally to an employer's performance of an employment contract? And that's a really open question. One can think of a range of circumstances where this could come into play. For example, with the awarding of discretionary bonuses in particular, an employer might say, well, you haven't been doing a good job and we're not really happy with how you've been working, or we don't think you met the standard required to get a bonus, but maybe the employee disagrees and sues and produces evidence that persuades a judge that in fact they did perform their job appropriately. It could apply to other areas, for example, change of job duties, where the employer might be caught out if they gave a reason that the employee later claimed was dishonest or provided in bad faith for why the job duties had to be changed. One particular instance where it might come up is when you have an employee come to you and say, oh, I'm about to buy a house and sign on to a big mortgage. So, is my job safe, right? And that's obviously puts the employer in a very difficult position, because no employer can guarantee anyone's job these days long-term. And what if the employer says, yeah, your job's safe to keep the employee happy, but maybe 3, 5, 6 months later decides, you know what, you have to be terminated. Things have changed, or even if maybe they were thinking about it, they don't want to necessarily tell the employee they might be fired, because obviously that can create strain on the employment relationship. And in fact, this could come up anywhere where an employer is relying on the terms as written in an employment contract. Getting back to the example of a change of job duties, maybe it's not uncommon to have a contract that says that an employee may have their job duties changed from time to time, and that won't trigger constructive dismissal, which is a perfectly valid thing to include in an employment contract. But then the employee might say, well, you exercised that right in bad faith, or you lied to me for why you were doing it. And then the other challenge we could face is, what exactly does bad faith mean in the day-to-day context of an employment relationship, or even the concept of dishonesty? Obviously, in any long-term relationship, there can be instances where parties are not entirely honest with each other on everything, because that could create considerable strain in the relationship. And a supervisor or manager, getting back to the performance issue, may sugarcoat news in terms of performance, or maybe not give as negative a performance review as may be warranted in the circumstances, in the interest of preserving that employment relationship. So this case has the potential to put employers in some very difficult situations, and we can only hope that if and when the courts do ultimately apply the principles set out in this C.W. Callow case, that they consider these day-to-day realities for employers. So here I just set out some basic tips. I know the advice is a lot easier to give necessarily than to follow, but if you follow some basic concepts here that might help keep you out of court. For example, being honest generally with employees, even if it means having some uncomfortable communications. And if things come up like, where the employee says, is my job safe because I'm about to buy a house? Well, you might have to be careful what you tell the employee, and you might want to document that with a note to file or in an email, so that there's not a he said, she said kind of situation that might come up later. And so basically you just might have to be a little bit more careful out there when dealing with your employees to avoid this coming back on you. And And don't necessarily assume that just because you have the right to do something under an employment contract or policy that this idea of being percolated out there by the courts may not come back to haunt you. So now we have some time for Q&A, and Jeremy is going to be moderating, handing out the questions to us.
Thanks, Landon. It's funny, if we could shoot the messenger, you're probably pretty happy. This has been a remote session. You've stuck a couple daggers in a lot of employers' hearts today. I'll tell you that.
So I don't like to be the bearer of bad news.
I bet, especially when it was your
these days when you're a management side employment lawyer, it kind of goes with the territory, I'm afraid.
It seems these days. Well, the first question is for you, actually. Here we go. Is a termination clause void if it states that a for just cause termination will result in no notice unless otherwise required by the ESA?
That would be fine, because there you're making clear that the employee will receive what they're entitled to under the ESA. So that in isolation would be okay. You just always have to be careful with the language that surrounds it. So there's not something that could be interpreted as taking away an entitlement, right? Like, let's say, for example, if the clause went on to say, and the employee will not receive anything else, full stop, right? Then maybe that gets interpreted as meaning they will only receive their notice required by the ESA, but would not get severance pay, right? And there's employees also, if they have 5 years of service or more with a payroll and the employer has a payroll of 2.5 million or more, then the employee would also be entitled to severance, even if there was just cause but not willful misconduct, et cetera, under the standard with the ESA. So, yeah. So in isolation, that language is fine. You just got to make sure what surrounds it doesn't undermine things. And that's the other thing the courts have made clear too, is that these clauses get read in as a whole, in a termination clause, as well as potentially in the contract and other clauses that might come into place. So, so again, by itself, that sounds okay, but you got to read the whole clause as a whole to make sure that it can't in any way, in any hypothetical scenario, be interpreted as taking away an employee's rights under the ESA.
And I suppose a follow-up, Landon, my own follow-up would be, if we learned anything in Waxdale, you can't just look at the whole clause, but there may be other clauses within the contract that stand alone, but may violate something to do with the same subject matter. And so we would have to look at all of the above, right?
Yeah, like for example, another area that principle might come up is, let's say you have a probationary clause that says you may be terminated during the probationary period. Well, let's say you call that a 6-month probationary period. So it says you may be terminated without any notice during the probationary period, which is 6 months. Well, under the ESA, you can only terminate someone without notice during the first 3 months. After the first 3 months, they're entitled to notice, regardless of what your probationary clause says, right? So, you know, watch out for those probationary period clauses too.
Thanks, Landon. The next question is for you, Ryan. If an employee tests positive for COVID-19 and has a position that has them all over the workplace, in this case, that's a mail clerk who I guess goes around delivering the mail that they're sorting, can that employee be named with or without consent?
You know, look, the answer to that is no. It's funny, you're just kind of burning. I'm dealing with a kind of a question like that with the regulator this morning, and no, they can't be named. You certainly need to. You can notify you notify people that they have potentially been exposed. They don't need any more details than that, and they need to be tested. Period. There's no need to name them, and in fact, naming them could expose you to liability under health law statutes.
Thanks, Ryan. All right, we've got a question for me. If during the IDO, the infectious disease emergency leave, the employee's contract naturally terminates or ends, does the employer owe the employee a renewed contract if the position becomes available again? If not, are they liable for termination, notice, or severance? First, under the ESA, the answer would be no. One issue might be the answer might change if in their contract you could imply an obligation on the employer to provide active employment for that period of time. So the short answer is probably not. The long answer is it depends on what you've promised in that contract, and if the work that needed to be done still needs to be done and will still take the time that would be taken when that contract was over. So if it's a temporary contract to deal with a specific project and that project still needs to be performed and it was paused during the pandemic, then putting someone else in that position arguably might be a violation of that entitlement to have that position back. But we would have to look at the specific circumstances and that contract as well. But again, by default, likely not. All right, then the next another question that we have here, which has to do with sort of unreduced pension amounts and returning retirees. This question really doesn't fit into the ambit, but it is a good question. So if that individual would like to follow up with us afterward, I would be happy to deal. You can just send me a quick email and we can chat. I don't have any other questions, and it is 1 o'clock. So perfect timing. Thank you very much, everybody, for joining us, to our presenters. Everyone did a great job. Fantastic. Stay safe, everybody, and we hope to see you next time. Take care.